Straight ahead on Law and Crime Daily. Grand jury proceedings in the police shooting of a Kentucky woman.
Breonna didn't pose a threat to anybody. She was literally in her underwear.
Did police think Breonna Taylor was at the trigger?
He said that she was the one that shot at us.
And an actor files a police report after getting punched.
Plus, Harvey Weinstein faces even more legal trouble. Our analysis is right here on Law and Crime Daily, covering court cases from coast to coast.
And welcome, everybody. So glad you're with us here on Law and Crime Daily. I'm Aaron Keller, along with Brian Buckmire and Terri Austin. We're breaking down 15 hours worth of recordings released in the grand jury proceedings surrounding the death of Breonna Taylor. Taylor was killed after police executed a no-knock warrant on her apartment in March. Though one witness and the police claimed they did announce their presence. One officer was charged, but not because of Taylor's death. People took to the streets, of course, to protest after the announcement of the grand jury's decision to indict the officer for wanton endangerment for firing into Taylor's neighbor's apartment. Kentucky Attorney General Daniel Cameron has since said prosecutors did not ask the grand jury to consider additional charges, nor did Cameron's office ask the grand jury to consider charges against the other officers involved. That's because he says his office determined the other officers' actions were justified. 3 officers fired their weapons that night. Sergeant John Mattingly was struck and has since recovered. An FBI report concluded Detective Miles Cosgrove fired the fatal bullet that killed Breonna Taylor. Detective Brett Hankinson was fired from the police force for wantonly and blindly firing into Taylor's house through a sliding door. Hankinson told investigators in March that he first assumed Breonna Taylor's boyfriend, Kenneth Walker, was the one who shot and killed Taylor. Here's some of his internal department interview, which the grand jury heard.
I asked him who else was left in the apartment. He said his girlfriend, and I believe he said she was dead inside the apartment. And he's asked me, what was going on or whatever. And I'll refer to that conversation to body cam because I think that's all in the patrol. And I don't remember exactly what I said. It was that conversation where you heard the medical assistant who's dead, and he said, my girlfriend is dead inside the apartment. And immediately my mind was like, did we come to something that already happened? That's what flickered in my mind. Did him and his girlfriend did he kill his girlfriend prior to us getting it? That's what I kind of, in my mind at the time, thought. And he said, no, she was shooting at you with her 9 millimeter. I don't remember his exact words, but I'll refer to the body cam. But he said that she was the one that shot at us, and that she was dead in the apartment.
Brian Buckmire and Bernarda Villalona reviewed the entire 15 hours of recordings. Bernarda, good to see you here again on Law and Crime Daily. So what key points jumped out to you as a prosecutor related to this grand jury presentation?
So, Aaron, having been a prosecutor for 16 years, I'll tell you that the role of the prosecutor is to seek justice and not merely conviction. It seems that Attorney General Daniel Cameron forgot that role, forgot that duty. Now, as the prosecutor presenting the case, the prosecutor serves as the legal advocate, and the jury is the fact finder. Throughout this entire presentation of 15 hours, I can tell from the very beginning that these prosecutors made the determination beforehand of what the facts were, and therefore did not present the charges of homicide for the grand jury to decide. By the prosecutors doing that, they unilaterally took the job away from the grand jury to make that decision, make that fact-finding decision. And that's where the prosecution went wrong here. For there to be any faith in the criminal justice system, there has to be transparency. And here, there was none. I think it was a huge miscarriage of justice for the prosecutors not to present the homicide charges for the grand jury to decide. If you don't present the charges, then the grand jury can't decide them.
Yeah, Bernarda, so you think this entire process was backwards. Brian, you listened to all of these recordings. What are your initial thoughts?
Yeah, so as a defense attorney, when we get a non-indictment, we call it a blowout, because you have to present so much information as a defendant that you get rid of all of the charges. That didn't happen here. The bar is so low. And what the Attorney General did here is they insulated themselves. They didn't have the actual witnesses testify. In fact, they had officers who interviewed them to show the recordings, and then when the grand jury, who had phenomenal questions, asked them follow-up questions, they couldn't, because the people who had the information weren't really there.
Yeah, remember, the grand jury is listening to recordings of the officers involved, not the actual testimony of the officers involved here. Okay, let's move along. Grand jury also heard, of course, a recording from one of the officers who was inside Taylor's apartment. Law&Crime's Terri Austin has that side of this very complex story. Terri?
Aaron, Detective Miles Cosgrove did not testify in front of the grand jury, but he did speak with investigators twice. Cosgrove was interviewed by the department in March, 12 days actually after the shooting. He was interviewed again in September by the Kentucky Attorney General's office. Cosgrove said he was told in a briefing that Taylor was considered, quote, a soft target, and insisted he heard the other officers announce themselves as police while they knocked on her door. He described entering Taylor's home behind Sergeant John Mattingly and encountering gunfire.
But at the threshold of the door, I am immediately overwhelmed with bright flashes and darkness, and what I describe as a movie reel that's doing that ticking where you see white and black and white and black. John is below me, and there are still these flashes happening, these vivid white and black flashes. And I know that I'm fired. Because I just sensed that I was fired. And I know I earlier told folks that, it's like a surreal thing. Like, if you told me I didn't do something at that time, I believe you. If you told me I did do something, I probably believe you too. So I know John, my friend that I've known for 15 years, has been shot in this confined space, and I know this person is down. And I sense that there's still these gunshots happening. So during this flashing light, I am seeing this human shadow figure. Tall human shape followed by like a rounder shape connected to it.
Terri, so it's certainly a harrowing scene that we're hearing described, but is there enough detail here? Is there enough of a chance for the grand jury to get in there and get questions answered, in your opinion?
I don't think so, Aaron. We need more details here. And more importantly, the grand jury needed more details. For example, if the warrant was originally a no-knock warrant, who decided to knock? They were entering a suspect's home. Why didn't they have a body camera running? They saw that Taylor had no weapon. Why did they shoot in her direction? There are just so many unanswered questions here.
So many questions, and we're sitting here asking them. Terri, I'll see you in a couple of minutes, because still ahead here on Law and Crime Daily, we dig further into the Breonna Taylor grand jury recordings. And later on, a possible avenue for an appeal for the man accused of brutally stabbing his parents and trying to get rid of their bodies using chemicals, even cooking methods. Law and Crime Daily returns right after this. Back now to the Breonna Taylor case, where we are analyzing hours of grand jury recordings. The Kentucky Attorney General's office presenting 2.5 days worth of evidence. The grand jury returned only an indictment against one officer for wanton endangerment for people in a nearby apartment. So we're taking a closer look at what was and was not presented to that grand jury. Law and Crime Daily's Brian Buckmire explains. Brian.
The prosecution's recommendation and arguments were not released to the public. But we're now learning members of the grand jury were allowed to ask questions during the proceedings. On the final day of the proceedings, an investigator with the State Attorney General's office answered some of those.
The first question is, were drugs, money, or paraphernalia recovered from apartment 4? And the answer to that is no. They did not go forward with executing the initial search warrant that they had for Breonna Taylor's apartment. And the third question is why body cams weren't activated. I can't answer that. I don't know why body cams weren't used for that. I believe they've changed their policy since this incident.
Was there a formal plan between the 7 officers as they made approach to serving the warrant?
I'm not aware of one.
And Ben Crump, the high-profile civil rights attorney representing Breonna Taylor's family, is asking Kentucky's governor to appoint a new special prosecutor to reopen this case. Here's part of my recent conversation with Crump about whether or not the police announced their presence before entering Taylor's apartment. We know that there are a number of different stories about whether the police announced or whether they didn't. Based on the changing testimony that you have reviewed, what do you think really happened when those officers went into that apartment? Do you think they knocked? Do you think they announced? Or do you think they did neither?
Well, based on the evidence we have, the witnesses said they did not hear them knocking and announcing. Kenny Walker, who was in the apartment, said he didn't hear them knocking and announcing. So based on the plethora of evidence that is not self-serving, it seems to me that they were exercising a no-knock warrant. And common sense will tell you a no-knock warrant permits you not to have to knock.
Everybody's here now to wrap this up. Bernarda, you're the former prosecutor. I got to get back to what the one officer said. If you've got a warrant to investigate what's alleged to be this big drug operation, why do you not execute it?
So I find something very fishy about that, Aaron. I do not believe that they did not search that apartment because there is footage of Detective Hankinson going back into the apartment after the shooting itself, especially since he should not have even been in the apartment since now it's the crime scene. Also, we know that crime scene detectives did go into the apartment. They took pictures. They looked through evidence. So I find that hard to believe that that wasn't done. The answer is you did not find anything.
So, Terri, I got a big picture legal question here. So hearsay is allowed in grand jury proceedings. Usually you allow it to try to get charges against someone, and here it feels like they use hearsay to try to insulate people from testifying.
Yeah, it does seem that way. I think they went out of their way to protect the police officers. You know, they made sure that the fact that they went in there and they didn't discover anything, you know, they kept that to themselves. I agree with Bernarda. They went in there and they didn't discover anything. So, you know, by saying they didn't search it, I think was hiding something, and, you know, admitting hearsay evidence to protect the police officers is definitely not the right way to go.
And Brian, you seem to be in complete agreement here.
Hankinson, Cosgrove, and Mattingly should not have testified. They're defendants. But every other officer that was there, every other person who lived in and around the area should have been able to come to the grand jury and give their information, because this grand jury needed more. And even though we don't have it, I do not believe they were properly explained what the law was and what self-defense was, because it's not applicable here.
I'm glad we have these recordings, because in essence, they're telling us, the four of us, that there need to be more questions answered, Brian.
Exactly. And they were asking all the right questions, and that's why I believe this grand juror really wanted to come forward and speak.
And when we come back right here on Law and Crime Daily, the case of the young man accused of stabbing his parents to death and cooking his mother's head on the stove. Plus, the actor you know from Ghostbusters and Honey, I Shrunk the Kids gets roughed up in New York. Stay with us for that and more. Comments made by defense attorneys outside the presence of the jury may shed light on a possible appeal for the man convicted of murdering his parents. It was guilty as charged for Joel Guy Jr. after prosecutors presented evidence that he stabbed his parents to death over Thanksgiving weekend and then dismembered their bodies, including cooking his mother's head on the stove and trying to use chemicals to speed up the disposal process. Among the key pieces of evidence was this jailhouse call from the defendant to a friend.
I don't really have much of a chance of being happy anymore, but you do. You do. Eventually you're going to meet somebody that's going to be in freaking prison. On that basis, I think you should probably just sort of consider me dead. I don't know what to say. I mean, I don't know that there is anything to say. I mean, here, I mean, tell me about idiot, tell me, why did I do this, blah, blah, blah.
Outside the presence of the jury, the defense objected to the use of that phone call. Here is some of the discussion which could point to possible grounds for an appeal.
We want to preserve for the record our argument that this call could be or would be fruit of the poisonous tree. Both those things had Mr. Guy not been arrested on the faulty warrant, he wouldn't have been in jail making the call. They wouldn't have gotten the faulty warrant but for the illegal search of the Knoxville house. So we just want to make sure that when we come back on appeal, if we do, no one will say that we waived the fruit of the poisonous tree argument.
Yeah, I certainly don't think that you're waiving. I disagree with it, but I think you have done a good job, Mr. Halstead, in preserving the record.
Okay, Terry, so we know some of the evidence gathered against the defendant at his apartment in Louisiana, was thrown out because authorities didn't have a warrant. That evidence included pictures of the bodies. I get that under the Fourth Amendment, but this new argument, they seem to be saying that the defendant's arrest is also fruit of the poisonous tree and you should throw out anything he said behind bars?
Well, technically, as you know, the Fourth Amendment does protect us from unreasonable search and seizures. And technically, the ill-gotten evidence could keep out the arrest as well. But you could argue there are exceptions to that rule. There are a couple of exceptions. And one of them is that if you could get the same evidence and inevitably discover that same evidence, then, you can use it. The other thing is they could get a warrant that was a good warrant and they could also use the evidence. So there are ways to get around that and use the evidence. And I think they can make those arguments. Obviously, the warrant argument is no good, but they could say that the evidence would have inevitably been discovered.
Exactly, Terry. You took the words right out of my mouth. I'm thinking inevitably someone would have happened upon the crime scene. They would have tried tracking down the son. They would have found at least something here. Brian, does the argument work?
Yeah, I think the inevitable discovery doctrine applies directly here, especially when you're thinking about some of the items that were found at Walmart. I mean, parts of the bodies are decomposing in a bin. You've got the gas on the side here. Eventually, they would have gone and looked at those items, gone back to see where they were purchased, and then got the video that really damaged the defendant here in this case. I think it's a long shot, make the argument, but I don't think it's going to work.
So the defense attorney here is agreeing that the law was properly applied. I look and say, hey, the defense made their record. The judge was really polite to the defense and said, I think you made your good point. I just don't agree with you. That was cordial, Brian. Yeah, I mean, this is one of those situations where you got to shoot your shot. And if you don't know what's going to happen down the road, as the defense attorney says. You've got to make that argument to preserve it down the road. Just in case the appeals court takes a look. Well, when we come back here on Law and Crime Daily, the off-screen legal lives of 3 Hollywood types, including Harvey Weinstein, against whom new charges are stacking up on the West Coast, less than a year after his sex crimes conviction in New York. We will be right back. The NYPD is looking for a man accused of attacking actor Rick Moranis. Officers say the man seen in surveillance video here was wearing an I Heart New York hoodie, and he struck Moranis in the head with a closed fist and then knocked Moranis to the ground. The attack happened in daylight hours, just before 7:30 in the morning, I should say. Moranis is best known for his roles in Ghostbusters and Honey, I Shrunk the Kids. Police say the actor was treated at the hospital for pain to his head, back, and hip, then later walked to the precinct to report the crime. Actor Shia LaBeouf arrested in California on misdemeanor charges of battery and petty theft after authorities there say he fought with another man and stole the man's hat. LaBeouf due in court in November to answer those accusations. LaBeouf was arrested for public drunkenness back in 2017 and on drunk driving charges in 2008. Former movie producer and convicted sex offender Harvey Weinstein is facing 6 new charges on the West Coast. Los Angeles prosecutors are adding 3 counts each of forcible rape and forcible oral copulation. That's in addition to a list of charges they've already filed against Weinstein. The new accusations stem from encounters with 2 women. The sum total of all of the charges Weinstein faces in California involve 5 women and date between 2004 and 2013. A New York jury convicted Weinstein of several sex crimes earlier this year, and he's currently serving a 23-year New York sentence.
After I was raped by Weinstein in 2005, I was confused. Why didn't I scream? Why didn't I fight? I thought I was stronger and I hated myself for being weak. That self-hate turned into shame and guilt. Shame that I never should have felt and guilt that was not mine to own. It didn't occur to me for quite some time that I might actually start to heal from being sexually assaulted. My single intention was to help survivors hold Weinstein accountable for his disgusting crimes. I hope that the sentence sends a clear message that times have changed and that more women need to speak out for themselves and that men and women need to speak out for each other. We need to show self-love and empathy to overcome centuries of illogical thinking that has normalized the sexual mistreatment of women. This is hopefully just the beginning.
Terry, we have an extradition hearing in upstate New York on December 11th to decide whether to move Weinstein from Buffalo, where he's behind bars, to California to face these charges. So this is going to get really interesting from here on out.
It will. And, you know, we saw this coming because the DA, Jackie Lacey, in Los Angeles, she was the one who announced these charges while the trial was going on here in New York. And we know he's already facing 23 years here. The question is, what will he be convicted of in California, and how many years will he get out there? And I've got to tell you, I think it will be a conviction because he's already been convicted once. And I think Jackie Lacey is really out to make sure that he's convicted in California as well.
Brian, is it possible for this guy to even get a fair trial on the West Coast after what went down here in New York? Everybody was watching here in New York. They know how it went down.
So, Aaron, I got to almost answer that as two different people. If you're asking Brian Buckmire, the attorney, I think, no, he's not going to legally get a fair trial because of the overexposure of this case and what happened in New York. If you're asking Brian Buckmire, the person, I think he's getting as fair of a trial as what he did to those women, allegedly, and I think he's going to get his comeuppance and his justice.
Brian Buckmire with a bit of a split personality here. So, you know, you have to feel for people who say they've been victimized and people who have convinced a jury that they've been victimized, like those that we just watched.
Exactly. It's tough to see. And I think I was there myself as an attorney watching here at the Law and Crime Trial Network, and it was tough to watch, but I think the right decision came about.
You know, that's why we have trials, to try to find the facts and get a justice. And thank you, Brian and Terry, of course, for being along with the analysis. That's all the time we have here on Law and Crime Daily. We appreciate you joining us for our discussion about justice in America.
I'm Dan Abrams, and this is the Law and Crime Network.
The only 24/7 network with expert legal analysis and gavel-to-gavel live trial coverage. Watch the Law and Crime Network today.